My name is Monica Taylor, and I'm one of the directors of Lawyers for Climate Justice Australia. We begin as we come into the room and settle by acknowledging that we're all meeting virtually on land that was stolen. Traditional owners of these lands never ceded their sovereignty. And Lawyers for Climate Justice Australia pays our deepest respects to elders past and present. And we acknowledge that Aboriginal and Torres Strait Islander laws, customs and practices have protected country for millennia. For First Nations peoples, the climate crisis is yet another chapter in the 235-year history of colonisation here in Australia. And we recognise there can be no climate justice without First Nations justice. And what a fantastic way to kick off this session, which is precisely about climate justice at the highest international level. So we are so thrilled to be hosting today's event. We've designed this hour with maximum time to hear from our guest speaker, Alofipo Fleur Ramsay. And I'm going to pass over to the chair of today's event, Sean Ryan, who is a member of Lawyers for Climate Justice Australia. And he's going to take us through some preliminaries about the ICJ decision and also introduce Alofipo Fleur. I just should say as well, Sean is a principal lawyer at Ninox Law. He started that law firm recently after a decade or more working on specialist environmental law practice with the Environmental Defender's Office. And Ninox Law puts planet ahead of profit and provides that specialist expertise. So a very warm welcome and thanks. Over to you now, Sean.
Thanks, Monica, and it's so great to have so many people join us for a very topical discussion of the ICJ decision. For a lot of lawyers on the call, but for those that are sort of new to this area, I just wanted to give a brief rundown of the context. So the International Court of Justice is one of the main judicial bodies out of the United Nations General Assembly. And I've got a photo as my background. So that's the court sitting, I think, in The Hague. And they have both a compulsory jurisdiction and an advisory jurisdiction. Nations have to sign up to the compulsory jurisdiction, which Australia has, but other nations such as the United States don't. But it can also make non-binding determinations, advisory opinions, at the request of members of the General Assembly. And that's what's happened in this case. Vanuatu, I think it was initiated by a youth movement, and then Vanuatu pushed for an advisory opinion on climate change. And that the legal team there was Blue Ocean Law that did a lot of work with some very clever crafting of the questions. Now, the advisory opinion is not binding, but it is quite authoritative in terms of statements of customary law, international law, and principles of interpretation. And that's, I think, why we're all here today, is that it's got lots of implications for Australia, for the Pacific, and particularly for climate litigators. And we are very lucky to have a member of the Blue Ocean Law team. And I'll just throw up, if I can throw up an image of the Blue Ocean Law team, led by Julian, a lot of fine legal minds in that. And one of my favourites, of course, is Alofipo Fleur Ramsay, who I met at EDO and is one of those fine legal minds that manages to think big, think radical, but then do the hard yards to work through the detail to get it across the line. And there's no better example than the outcome in this case, which Fleur and the team had a big part in. So personally, I'm quite excited to have an opportunity to chat to Fleur today. And let me bring up her bio so I don't forget anything. So Fleur's now a barrister at the Victorian Bar. She was formerly international attorney at Blue Ocean Law, working with Vanuatu and the Melanesian Spearhead Group. She put submissions before the ICJ. The Vanuatu spearheaded the ICJ climate advisory opinion and the diplomatic and legal campaign. It took a lead role in the formulation of the legal questions in the proceedings. Fleur was co-counsel for Samoa before the ICJ, and Fleur holds two chief titles from Samoa, Alofipo and So'oalo. And before I get you to jump into the ICJ decision, Fleur, I'd love it if you could just tell us a little bit about those chiefly titles, because I find them fascinating, and then we'll get stuck into the meat.
Yeah, thank you. I just wanted to acknowledge that I'm zooming in from Melbourne, and I wanted to pay my respects to the Wurundjeri people, and particularly to their elders. So Alofipo is a chief title from my grandfather's village in Savaii, which is Saliola. And I've explained before, I actually really love the title. So Alofipo was a ancestor, and Alofi means circle and Pole means night. So it means circle of night. And it was an ancestor who drank kava at night with my ancestors and ghosts. And that's what the literal meaning of it means. So'alo is another chief title, and it refers to the tapa, which is or siapa, which is a type of bark cloth, which belonged to one of our famous chiefs who was a woman, Salamasina. So So'alo is the tapa of Salamasina. That's so they're really amazing titles, and they're also honorific, and I hold them on behalf of my family, and people who know the titles will know where my title comes from.
Thanks, Fleur. And before you kick off, I did forget one housekeeping, which is because we've got this meeting format for today, if people can post their questions in the chat, and Karen from Lawyers for Climate Justice will be reviewing those and bumping ones up to the top, and I'll throw to Karen to ask some of those questions of Fleur. So anything you got burning questions, throw them in the chat and we'll try and get to them at the end. All right, well, I'll hand over to you, Fleur, if you're ready to go.
Great, thanks. So I've got a talk that I prepared. So I'm just going to read the talk and then answer any questions that come. So I guess I wanted to start by saying that I am exceedingly pleased that the advisory opinion is groundbreaking and far-reaching. And I have to admit to having been extremely nervous when the president of the court started to read out the opinion. At first, I did not know where it was going, but as the president read on, I started to comprehend the momentous shift that was occurring in international law and in the way that climate justice and climate change is framed. Well, I'm going to draw out some of the key takeaways in the opinion. I wanted to first talk about how we got to this result, because I think you can't separate the process from the court's advisory opinion. And by providing this context, it makes for a richer understanding of the opinion, and also my audience are lawyers for climate justice. So I think it's important to think about the way that a case is brought and the kind of result that you're looking for. So in previous talks, I have described the Pacific's engagement with the ICJ, particularly Vanuatu and the Melanesian Spearhead Group's legal strategy, as an insurgency. As two of my colleagues recently wrote, the result started with a group of Pacific students who did not know that it was impossible. While the result was what more than I dared to dream, we did demand, I think, the impossible from the court. And by doing so, we changed the court, the international law applying to climate change, and the way that climate change is framed. The seismic shift was palatable after the 2-week oral hearing had concluded that the court was changed. Not only was this advisory opinion proceedings the largest proceedings in the court's history, but many states, especially from the Pacific, appeared before the court for the first time in their history. Many of these states had gained independence after the architecture of international law was already in place, but they came with a vision of international law which they demanded was not indifferent to their plight, as Samoa put it. This also changed the optics of the court. Many of the Pacific advocates wore clothing, flower garlands, or a ceremonial necklace in court as they advocated for their states and peoples in a proud showing of our distinctive place in the world. But our advocacy, especially the Pacific's advocacy, was notably different too in three important ways. First, Pacific states brought the voices of individuals and communities with them, which are rarely heard by the court because the court is a court of states. Vanuatu and the Melanesian Spearhead Group, or MSG, started the oral hearing. The last person to talk to them was Cynthia Hunuhi, a Solomon Islander who spoke about her people and the impact of climate change on them. Within my blood flows, Cynthia said, the collective memory of my ancestors who were conceived from the divine law and have thrived on our island since time immemorial. I stand before you not as an individual, but as the living embodiment of the voices of our people, past, present, and future. As she spoke, you could see the whole bench lean in, forward, captivated by her softly spoken advocacy and powerful words. I travelled across Melanesia with two of my colleagues to obtain community testimony for Vanuatu and the MSG. In their own cultural terms, individuals and communities spoke about the destruction that climate change was already having on their lives and their vital places. By providing this testimony, the court not only was forced to contend with their claim to a right to a dignified existence, it also had to contend with actual devastating harm already occurring across the Pacific. We were able to successfully combine the actual harm with targeted scientific messaging from the Intergovernmental Panel on Climate Change, the IPCC, which painted the stark reality, which the court accepted, that even 1.5 degrees is not safe for most nations, communities, ecosystems, and sectors, and poses significant risks to natural and human systems. I have no doubt that their testimony animated the scientific messaging and worked a magic on the hearts and minds of the judges of the court, especially when you read the scientific section of the opinion and the court's finding that significant harm to the climate system and other parts of the environment has already occurred. So, I mean, this is a really important point. As you know, I think a lot of climate litigators have been caught with a future risk, future harm, particularly in relation to 1.5 and 2 degrees. We took a completely different approach, which is harm's already occurred, it's already dangerous, it's already bad. And we were able to do that with very targeted scientific messaging, as well as this testimony, which proved the harm. We didn't have to prove it, but it proved it in the hearts and minds of the judges. Second, the advocacy of the Pacific was different because it sought to reframe climate change. Vanuatu had drafted the legal question, and it and its legal advisors, including Blue Ocean Law, fought hard to ensure that it was not compromised in the negotiations, which then referred it to the ICJ. The question asked the court to answer it by referring to a wide corpus of international law and not just the Framework Convention on Climate Change and the Paris Agreement. As Vanuatu and the Melanesian Spearhead Group had said in their oral statement, the Paris Agreement had been reduced to a polluter safe harbour and a trap for everyone else. Vanuatu argued that other international legal obligations, such as human rights and the customary international law duty to prevent significant harm to the environment, applied to climate change as well. Further, the question was framed on the basis that some states were already in breach of these broader obligations and that significant harm to the climate system and other parts of the environment had already occurred. So if you look at the question, it's already framed in that way, that some states have breached these obligations apply, and that significant harm had already occurred. Third, the advocacy was different because lawyers and advocates who were not experienced international lawyers, like the ones who regularly appear before the court, appeared before the court. As my colleagues put it, it brought many new voices from all corners of the world who addressed the court firmly and decidedly with the authority that only genuine conviction and first-hand experience of a situation can give. And these are the voices that carried the day, overcoming and overpowering those of some highly experienced counsel who at times did not appear to fully grasp what was happening before the court. Because many of those experienced international law counsel did not understand the case, we were called all sorts of names, including activists, radicals, and extreme. Our colleagues included international lawyers who were experts on climate change, but this did not seem to temper the criticisms that were made of us and the case that Vanuatu brought to the court. My colleagues put it this way, that Vanuatu and its legal strategy was treated with much skepticism, sometimes even sarcasm, and unrelenting pushback. I was told that Vanuatu's case was extreme by another international lawyer who was supposedly on our side. It was a form of gatekeeping, which I believe failed to grasp the moment and the necessity of making the most progressive arguments open to us. As a Pacific Islander myself, I felt a profound responsibility to Pacific peoples who are facing collective, existential, and literal death from the adverse effects of climate change. Such a moment calls for pushing the envelope. Courts do not offer justice unless it's demanded, but that demand also has to be accompanied by skill and technical brilliance. When I told one of my colleagues who had worked on Vanuatu submissions that they had been referred to as extreme, his response was that they were extremely robust and extremely well researched, which they were. Other Pacific states and intergovernmental organizations made more radical arguments. This included arguments that raised racial discrimination and even genocide, and these aren't dealt with by the court, but in my view, these pushed the court so that when it came back to the middle had already radically moved towards the result that we ended up with. While I was on a high after the opinion was read, I was more relieved because I knew I would have to travel back to the communities who had collaborated with us in these proceedings to inform them on the outcome of the advisory opinion. I feared having to tell them yet another court had failed to rise to the moment and take seriously their testimony about the devastation of climate change on their lives, territories, and culture. And I didn't have to do that, which is a relief. While many of those communities still face a bleak future, and I can't sugarcoat it, the damage is already done. I know that it will make a difference to them that their collaboration helped to bring about this major shift. And as a lot of climate lawyers understand, it's changed our world in the climate litigation sense. So I'm going to now briefly highlight some of the key aspects of the opinion. I need to say there's so much subtext in the opinion, and it's got so many important implications that I actually think it's going to take a lot of time to kind of work through them and to draw to close all the loops and all the gaps. So I'm just going to keep my comments extremely high level, and obviously I can't cover everything. So first, obviously, the court accepted that there is a range of treaty and customary law obligations that apply to climate change, and it rejected the arguments made by countries like Australia and the United Kingdom that the UNFCCC and the Paris Agreement were specialised agreements which covered the field, or as lex specialis, we already know that. Second, I think probably one of the most important findings is that the court found that 1.5 degrees and not 2 degrees is the agreed primary temperature goal for limiting the global temperature increase under the Paris Agreement. So note, under the Paris Agreement. The court found that what the parties had agreed to in subsequent decisions represents, so they found it on the basis that they'd agreed to it in subsequent decisions. It represented the best available science, and it was more able to achieve the UNFCCC's objective to prevent dangerous interference with the climate system, which the court considered was the object and purpose also of the Paris Agreement. What is more far-reaching is that the court found, in effect, and this is an argument I'm making, that 1.5 is legally binding on all states. This means that all states' mitigation commitments in their nationally determined contributions, NDCs, must be, when taken together, capable of achieving the temperature goal of 1.5 degrees. In other words, all states, particularly the large emitters, must take ambitious mitigation measures in line with 1.5 and the best available science. While not explicitly spelt out by the court, the subtext is that many states, I think, are already in breach of their Paris Agreement obligations. Given that most large emitters do not have current NDCs which are in line with the 1.5 temperature goal, this means that these states are already under a duty of cessation. So if you go to the consequences and legal obligations when you're in breach, one of the things that automatically you have to do is cease. And that requires them to employ all means at their disposal to reduce their greenhouse gas emissions and to take other measures in a manner and to extent that ensures compliance with their obligations. So you can read it in two ways: one, that they're already in breach, or that they have to very quickly change their NDCs to make it comply with the court's decision. Third, it's worth paying attention to the court's opinion on what the customary law duty of to cooperate requires. Particularly in relation to obligations under Paris Agreement, the court said that the duty to cooperate takes on a special importance in the context of the need to reach a collective temperature goal. States must cooperate to achieve concrete emission reduction targets, or they suggested developing a methodology for determining contribution of individual states. So you would have seen that the court also accepted under the climate agreements that there's common but differentiated responsibilities and also respective capabilities, which means that not all states, you don't have an equal amount for each state. It's got to be based on this idea. And so they're saying that the duty to cooperate also includes a duty to create a methodology. And obviously for climate activists, this is something that they can do themselves to provide for some kind of advocacy, obviously based on the opinion, but that might just be thinking about updating fair share methodologies which already exist, but also making sure that it fits in with what the court said. So the other important thing, I think, is that the court says that the duty to cooperate and prevent significant harm to the environment constitutes a legal standard for determining whether any existing forms of cooperation, including treaties, and their implementation still serve the purpose, and whether further collective action must be undertaken, including the establishment of further treaty-based obligations. Now, I think we can read this in a number of different ways. But I think it means that obligations of states aren't static, that they can't just do what they've done with the Paris Agreement and the UNFCCC for 30 years and treat it as a safe harbor and not do anything. The duty to cooperate actually requires action. And as the court said, climate change is a common concern. Cooperation is not a matter of choice for states, but a pressing need and a legal obligation. So I think there's some really interesting things in the duty to cooperate as well. Fourth, the court found that the customary duty to prevent significant harm to the environment also applies to climate change. The court rejected arguments that the duty was limited to direct cross-border harm, such as, if there's a leak of some kind of chemical that ends up in the borders of some other state. That was the way that this transboundary harm rule was thought about previously, and big emitting states said, well, it's limited to that. The court said, no, it also applies to global environmental concerns, including the climate system. Now, for lawyers, you should look at the definition of the climate system, because it's a very broad definition, which includes the oceans, it includes ecosystems. And so you can think about it as a global entity, but also it exists in the borders of each state. So oceans, ecosystems, etc. So when you're thinking about it, you're not thinking also in the way that normally we would think about looking at whether a particular project is going to have a particular effect on a particular state or, cause sea level rise or something like that. The question is it going to have a significant effect on the climate system? And that just might mean by increasing global warming. So I think the kind of causation in this respect is much easier to think about. And so the court basically said the states are required to prevent significant harm to the climate system, and that you have to take into account the cumulative effects of everything else that everyone else has done. And that includes various private actors. So that means that bad faith arguments such as the drop in the ocean argument just are no longer credible. I just don't think you can credibly run those arguments anymore based on this reasoning. And states must consider the cumulative effect of the activity such as a fossil fuel project on the climate system. I think that's pretty clear, and it's objective now. And why is it objective? Because the court said that significant harm to the environment has already occurred. And it found it based on the science. There's a particular paragraph where it says temperature rise, sea level rise, all of these things, significant harms occurred. And I think this means that states are under it does mean stringent due diligence obligations. They have to take into account the best available science. They have to undertake environmental impact assessments, and they have to take all measures at its disposal to prevent the harm. And there might be some interesting questions about what that means. I'm not going to go into it now. I think these are the implications that we have to think through. But you can read that in multiple different ways. Okay, so the fifth, I just want to mention that obviously the court said that conduct that causes significant harm to the environment includes fossil fuel production. And there's a separate opinion or a separate declaration by two judges, which kind of give a much more kind of elaboration of that meaning. And so they also said that the failure of a state to take appropriate action to protect the climate system from production, including the granting of fossil fuel exploration licenses and the provision of fossil fuel subsidies, may constitute an international wrongful act that can be attributed to a state. So in other words, states may breach their international law obligations by allowing fossil fuel production to continue. While the court did not provide much further detail on fossil fuels, the statement is extremely important in the context of what I've already said above in relation to the requirement of all states, NDCs, have to be capable of achieving 1.5. And we know that continued fossil fuel production or new fossil fuel production is inconsistent with that. So again, you can draw out some of the implications. It's going to be an interesting thing for states to also try and justify continued fossil fuel production under the customary duty to prevent significant harm to the climate system. So at the very least, it puts states who produce coal, oil and gas on notice that they are under legal risk at the very least. And it may mean more. So finally, I'm just going to come to human rights, because obviously this is really important for domestic litigation. So I've got to say, I have very mixed feelings about the human rights section. So on one hand, I feel that the court provided some useful comments and actually goes much further than many advisory opinions have on human rights. And I think it also is useful if we use positions of states like Australia as a yardstick, because the court went quite far in this respect. For example, Australia in the Billy communication before the Human Rights Committee, and also in its refusal to pay reparations to those authors, said that it didn't agree that the right to life extended to the general effects of climate change. And the court explicitly confirmed the Human Rights Committee's position an approach that the enjoyment of the right to life may be impaired by the effects of climate change. Further, the court recognised that a clean, healthy, and sustainable environment is a precondition to the enjoyment of many human rights, which was an argument that many Pacific states made. So we made all of the arguments necessary to show the interaction of the environment and human rights. And I think even if the court stopped there, I think this is still very important. And I do think with domestic human rights, it is an argument that I think is worth thinking about in relation to those domestic regimes, because obviously the same thing applies, that a right to a safe, to a healthy environment also is a precondition for all of these rights as well. And I think on a progressive reading of the opinion, I do think that the court found that the right to a clean, healthy, and sustainable environment has achieved customary international law status. So on a progressive reading, that's what I think the court did do. On the other hand, I think the court's human rights section is disappointing because I think it could have elaborated on the human rights obligations of states further and with greater clarity. And it doesn't address cultural rights, which was ardently put by many Pacific states, and obviously such an important thing for many communities. And it also didn't really address the right to self-determination, which again was put by many Pacific states as a right that's been infringed and affected by climate change. But it did mention it in the context of the loss of statehood. And I think probably the important thing is it didn't say anything that could harm a finding in the future. And so that's what I'd also say in relation to this human rights section. It didn't do any harm. And it didn't do anything that undermined the International American Court of Human Rights advisory opinion on the climate emergency. It actually referenced that opinion, didn't endorse it, but it also said here these regional bodies have looked at the way that rights apply to climate change. And it didn't, importantly, foreclose the application of human rights applying extraterritorially. Now, this is important because under treaties, the state owes human rights obligations to its own citizens in its jurisdiction. The question of extraterritorial operation is whether, which is obviously very important to the Pacific, whether other countries that are causing the most damage also owe human rights obligations to other communities, such as in the Pacific, particularly when activities are taking place on their jurisdiction that they have control of. Now, the Inter-American Court says, yep, that you are under the effective control of that state for human rights basis. The court didn't say anything against it. It didn't also say that that they did apply, but there is a very interesting and important sentence at the end, which basically says, well, while this extraterritorial operation may apply for treaty human rights, the scope of customary human rights, or those that exist under customary law, is different. And even though it didn't really say that, except for maybe arguably the right to a healthy environment, doesn't, even though it didn't say other rights have customary law status, it's in there. They mention customary law, human rights. They also refer to the UN Declaration of Human Rights when they're looking at the rights that they looked at. So I think implicitly they are recognizing that there are some human rights that have customary law status. So I think that's important to think about as well. Okay, so there are obviously limitations that I'm not going to go too much into, and one of them is one of the important climate justice aspects of the claim that was put before the court was to recognize that there are some states that have caused the most problem, but particularly the justice kind of what are the legal consequences for small island Pacific states whose contribution are negligible If you read Judge Youssef, he slams the court for not really dealing with this issue, but also sets out how you may think about it. And so there's a lot of questions around temporality, such as when did states know? He says 1980s, that climate change was going to be a problem. Then you have to look at when a particular international law obligation applied, and then you have to look at when the emissions or the conduct occurred. So there's a lot of kind of issues in relation to that. Actually on a very generous reading of the judgment, I actually think that the court did leave this question open, because once you get towards the end, particularly around some of the statements it talked about attribution, causation, it does contemplate the fact that there's going to be some injured states and a plurality of states that have caused the most problem. So I do think that the architecture is there for us to use for future cases, particularly for litigators who may be representing injured states such as the Pacific Island state. And then one thing I hate about the judgment is I think that the last paragraph is awful. I don't really know what they were thinking, but I'm just ignoring it because I think the rest of the judgment makes up for it. So that's it.
Is this the one where it says, "Look, we're just lawyers. Everyone's got to do their part"? Is that the 4 or 5?
Yeah, we're all responsible, which is
we're all responsible.
Not what was argued before the court, but yeah.
Well, thanks, Fleur. And while the audience sort of warms up and puts some questions, I just want to say, look, thank you to you and Blue Ocean Law. Like, thinking bold, being radical, trying to aim for what we really need, and not self-moderate or compromise. Someone told me the other day to accept defeat is to lose your soul. And so, you've got to aim for what is necessary. And while those questions are coming in, I'll kick it off. And I want to loop back on what to me is, I think, your central point, and it's, I think, something you've been trying to convince me and others of for years now, which is that, like, Paris is kind of a mirage. Like, we've been, when we started, we were using Paris as a sword, saying, "Oh, you got to comply with, NDCs, and you got to get it down to 2 degrees." And we thought we were using Paris, to our advantage. And this judgment just sort of flips the table on that and says, well, no, the damage is here. We're talking breaches of human rights, loss and damage, and liability. And they're forced to use Paris as a shield, and it's turning into not a great shield for them. And so, and like in reading this judgment, I was like, oh, that's what Fleur's been talking about. And I think people really need, it's like a seismic shift in climate litigation. And, some of the cases have started to touch on it, with particularly human rights jurisdictions, and saying, look, let's stop talking about Paris. That's for the other side to raise as a defense. This is just damages. Is there anything more you want to, because I think that, and people walk away from this seminar with only one takeaway message for me. Like that's it. Did you want to?
Yeah, I think I do think the Paris targets, like climate litigators have been like a deer stuck in headlines. So kind of a bit frozen and can't look away. And I do think by doing so, I mean, you can see it also in kind of the European Court of Human Rights as well, where there's still a focus on future harm, rather than the fact that you can't divorce that harm from what the conduct that's already occurred, the harms that have already occurred. And so we did, like the IPCC, if most of you guys have read it, it's not, it's very kind of like dead language. You really have to go in and pull out all of the kind of the important aspects that show harm. But when you read the ICJ decision and you read that scientific section, it is focusing on irreversible losses have already occurred. Widespread changes have already occurred. So I've been arguing for a long time, just temperature increase is damage. Temperature increase is damage. is harm. And and so I've been trying to kind of get people to think about taking damages cases, bringing people to account for the harms that they've already caused. That said, my argument still is the case that the best people to bring those cases are Indigenous peoples. And that is because it's much easier to, the threshold is lower because of how important ecosystems are to their lives, to their subsistence, to their cultural rights. It's easier to get the harm. So, for example, with that German case, imagine if that glacier was an ancestor. You might have actually then got a better chance of proving kind of the damage. So I do think, again, like having an equitable and justice kind of reading of it is recognizing that there's particular communities now that can take these cases and should be taking these cases, should be enabled to take these cases because of that harms occurred. And I do think that the court did get a very different understanding of harm because of the way that all the Pacific put to them, this is the way it affects us. It affects, we're subsistence people. Samoa said like 80% of our people are still subsistence. So it's the threshold for crops. The heat threshold is 1 to 2 degrees, which it is, which we've already exceeded in the Pacific. Then what does that, that's harm. So I think that was why it was important that the Pacific was there. And I think they were able to bring things that other states didn't, which really concentrated, I think, the focus of the court.
I'm noticing there's some good questions coming through in the chat. And as much as we sort of stepped over the Paris Agreement, I mean, as you sort of touched on, there's implications for the NDCs. So someone's asked, what's the implications for the upcoming release of Australia's NDCs? And let's just, leaving aside customary law and significant harm, even within the Paris Agreement, the court's interpretation of due diligence seems to create a new level of obligation on Australia to, as you were saying, collectively achieve. And maybe you want to expand on the what do you call it? The common but differentiated, having regard to circumstances, and what that means for Australia.
Yeah. I mean, so it's the common but differentiated responsibilities is a creature of the climate change agreements. And the UNFCCC recognizes that some states have historical emissions and that they developed earlier on. And by doing so, use fossil fuels and created emissions in the atmosphere. And that's got to be taken into account, and these states have to lead. It's also had a bit of a calibrated kind of understanding as well to recognize states like China, where national circumstances may change, where therefore at a certain point China will have, and probably has now, more obligations than it would have if it was just common but differentiated responsibilities. But what does that mean for Australia? If you look carefully at the decision, the language uses things like adequate. So an adequate contribution based on the best available science, based on common but differentiated responsibilities. And so the methodology and what that means in practice has to be worked out. But I would say that Australia has to update its NDCs so that when taken with all the others, it has to meet the target of 1.5. It can't be what they're doing now, where we're heading towards 3 degrees. I think that's pretty clear. And I'm not someone who knows the kind of the accounting or how you would do that. I do think you then have to read it very closely with the duties in relation to the implementing the NDCs and what the content is. Obviously, Australia relies on technologies which potentially may never happen, such as carbon capture and storage. I'm not sure if that can fly now in relation to the ICJ decision either. So I do think that it's really important for lawyers as well as NGOs that are advocating in this area to go and get some advice and to try and kind of understand what the implications are for Australia, and not to just use what you've been using now, because you're doing a disservice to everyone if you're not updating what your expectations are on Australia. And that needs to be done. It's got to be worked through. It's going to take a little bit of time. But I do think that that has to happen as a matter of urgency.
Some good questions coming through, and this is a broad one, but implications for climate litigation. There's going to be a few climate lawyers and people interested in the next cases. Did you want to? I mean, there's quite a multitude of ways that this is going to be used, but did you want to pick out any ones that you haven't touched on yet in terms of how you see this judgment being applied or relied on?
Yeah, I mean, I'm thinking of Smith and Fonterra, not particularly the Smith and Fonterra, but there was another case, Smith and the Attorney General, where the court's assumption was that states have a lot of discretion around policy discretions around what their emissions reductions are. I mean, there is, unfortunately, as you know, in a lot of jurisdictions, including Australia, a separation between domestic and international law, and that needs to be thought through. But I do think that that there might actually be more teeth in these kind of cases now around what NDCs are, even though I do think that we should be focusing on harm. And also, I think there is some very useful, obviously from a fossil fuel perspective, fossil fuel companies probably like to think that what they're doing isn't unlawful. But at least from an international law perspective now, states are responsible for what they're doing, that can be attributed to the state. So there are implications, I think, for fossil fuel companies as well. But I think the main thing is the symbolic shift for courts. So I think that the way that courts now will think about the Paris Agreement, that's been used in so many cases to undermine climate justice claims. And I just don't think that it can be used in the same way anymore. They may find another way, but not by saying this is what Paris does.
Yeah. And I think there's already cases, like obviously our subnational jurisdictions that have human rights, like Queensland, can use international bodies such as this in the interpretation. And I would expect, I think the EDO is running a case in the Queensland Land Court at the moment for ACF, Winchester South, where that might be the first case in the world to, make submissions in relation to the implications of this decision on coal in Queensland. So I can see it being picked up a lot. There's a great question that I'm going to springboard into a broader question I had, but the specific one is whether Tuvaluans were interviewed, given the existential threat of climate change and sea level rise in Tuvalu, and if I could spring off that to touch on, I think, correct me if I'm wrong, it was Julian Aguan who did the paper about that I think you presented at EDO about reframing the climate change from the Pacific and looking at the oceans and the people who are most affected and the size of their territory. And I kind of got the feeling in this judgment that there was a shift in attention from the global north to sort of the global south and the Pacific, and the people who don't, as you say, don't produce but get impacted. So yeah, I wonder what you think about how significant it was, that shift in geography and perspective, while also answering a question about whether specifically Tuvaluans were presented evidence to the ICJ.
Yeah, I think there were some statements from them and also from Kiribati, which is similar as well. But even within countries, like I went to Verabai community and got evidence from them. And they're a community that their origin is the place where they are from. And there's very little land for them left. So I do think um, even though the court really didn't address those, I mean, some of the individual judges did look at some of these testimonies and the importance of them. I do think that the decision's really important for the Pacific, because we've been arguing for a long time, because we were kind of forced into it, even though 1.5 is a concession itself, that we need 1.5 to continue to stay alive. And this case just gives us that as an advocacy tool. Is the world going to change tomorrow? No. But it does make it harder, I think. Like, I think we've discursively trapped a lot of these states, and it's going to be interesting to see what they come back with. But I do see it as a shift, which hopefully other judges will have the kind of courage that I think the ICJ showed, that stepped up to the momentous occasion that climate change requires, I think, of any thinking and rational person.
Well, unfortunately, we're getting near the end of the time, so I'll just have one last sort of wrap-up question, and then I'll hand over to Francis to close the proceedings. And it's sort of like, and there's a lot of young lawyers and volunteers on this chat wanting to know how they can best make use of this judgment in their own jurisdictions, such as Papua New Guinea. What are some takeaway messages that you would give to young students about how to make the most of this judgment or raise awareness of it, or any thoughts?
Yeah, I mean, not all Pacific states. I mean, Papua New Guinea is a very interesting state in itself because it also produces gas and oil. But I think there's some really important messaging in there also around sinks and reservoirs. So in relation, Papua New Guinea's got the third largest rainforest. I think some of the logging concessions and issues now will raise some questions for Papua New Guinea in relation to their obligations and NDCs. So I do think that it provides a lot for Pacific lawyers working in places like Papua New Guinea that are trying to actually defend the environment there as well. And obviously, I think, I think that it's going to be really thought about and thought through for anyone who's working in the Pacific. It has to be, because this is not the end of this is the beginning. It's a reset. It's the beginning of what's to come. And I think that's the beautiful part of it. And I was actually also really happy that it's given renewed hope to a lot of climate lawyers, including myself. And I think we needed it because, it's a hard road to do this work. And I think, like, when you get a win like this, it really does shift and it gives you the energy to keep going. That's the important thing as well.
Oh, look, I think that's a really great point to end on. And look, thanks again for your time and all your work on this case. It's a wonderful outcome. And look, a lot of climate litigators on this call really appreciate the work you've done, and we'll do our best to make good use of it in future cases and continue the winning streak, hopefully. All right, well, we're at time, so I might hand over to Francis from Lawyers for Climate Justice to close the proceedings. But look, thanks for everyone for joining us. Really appreciate your time, and look forward to seeing you at all and more of these events in future.
Yeah, thanks so much. Thanks everyone for coming along. And yeah, that's a great place to end the conversation today, I think. As a member of Lawyers for Climate Justice, I just wanted to say a huge thank you to Sean for chairing the discussion, taking the questions. We really appreciate your generosity, your time, and your expertise. And of course, a huge thank you to our incredible speaker, Alofipo Fleur, for everything you've shared with us today, and your ongoing work as a leader in the Pacific and globally fighting for climate justice. Huge thank you to the audience. Thanks for coming along. Great questions. And an obligatory plug for Lawyers for Climate Justice Australia. If you're a law student, a lawyer, a legal academic, please consider joining as a member, or you can follow us on LinkedIn. We're building a community of legal professionals committed to climate action. So please join us. Thanks, everyone.